Michael Williams, broker owner of Global Realty Group. Our company specializes in estate sales, which includes trust and probate. One scenario I wanted to discuss in this post is a client gave us a call the other day. Says, Mr. Williams, we've been trying to contact the attorney. We haven't got the call back yet, so we decided to give you a call. We found another property that our mother had that we weren't aware of. So we want to make sure that we don't have to go through a whole nother probate. Do you have any advice on this? Well, the first thing I tell them is that I'm not an attorney. I'm not a CPA. I can't give you any advice regarding this. I can give you some consultation in terms of my expertise, but I am not an attorney. Please get in contact with your attorney if you have any questions about this. But I did say, based on my expertise and my experience in many of these types of cases, I advised them that it is a very important aspect of this, so they won't have to go through a separate probate when you find other properties, to make sure your attorney has a clause in the orders that basically state that any other properties that are discovered during the probate case are added to the current probate case to avoid all those additional fees and costs, which starts with the $465 filing fee. So the actual clause is called an ominous clause, and that clause should be in the orders when it's filed with the courts. So you may want to be sure, if any of you out there have found that the decedent, your mom, your dad, your grandfather, grandmother, had some additional properties that you and other heirs in the family are not aware of, to make sure that that clause is added so that you won't have to go through the process again. Another issue that came up, we got a call a couple of weeks ago from a decedent's son. The decedent was a lady we knew, and the son, of course, we know him very, very well. The son does not get along with the stepfather. The mother remarried, and the two of them just oftentimes, you see that happen. They just didn't get along. So there's a dispute ensued about who's going to take care of the estate, who's going to be the personal representative overseeing everything. Of course, the new husband wanted to be involved in the whole process and wanted to push the son out. The son comes in and says, hey, well, this is my mother. I don't want you involved in all this. I've been here from Jump Street, with my mom. Helping her, taking care of her, and taking care of business way before you came into the picture. So this dispute ensued. So then they end up going to court. And the courts have been pretty solid on where they stand when it comes to the ranking of a possible personal representative that will be appointed by the courts. And the higher rank would go to, believe it or not, the surviving spouse. And that's regardless of what the son or the daughter's position is about this. They get into court and they argue back and forth about this, but the courts are pretty clear on this. This happens 9 times out of 10. There is the rare occasion where, if it can be proven that there's some extenuating circumstances or reasons why a person should not be named a personal representative, such as maybe the person is on drugs or the person is not mentally competent to handle the duties of the appointment, then at that time, then the court may consider putting another party in. So we will be giving posts and updates pretty frequently here. So be sure to tune in And again, we'll be putting these posts out every few days about different topics that hopefully can help many of you out there. I want to give some information about how to contact us. My office number 310-538-6884, and the email address is broker@globalregroup.net. Our website www.globalregroup.net. Talk to you all soon.